Right, Nicky, our
Thanks,
favourite lawyer.
Charmer. Thanks, Jag. You've invited me here today to talk about disability in the workplace, but given the emphasis on wellbeing, I'm actually going to focus on health and safety and wellbeing and disability, because I think they're important points to cover, particularly at the moment in relation to COVID. I've only got 15 minutes, and I think you'll probably be aware that there is a lot of legislation in this area. There is an awful lot of case law, so I'm going to talk really quickly. But really what I'd like is to just give you some key points to think about, and hopefully you can use these slides as a bit of a reminder and a reference point when you're dealing with your legal duties regarding health, safety and wellbeing, and looking at the protection which is offered to employees under those issues as well. Okay. And I'm going to talk about your legal duties in respect of health and safety. And I think I've been a solicitor for a long time now, and I've had a handful of questions about health and safety over the years. And then, of course, suddenly COVID came, and I've been dealing with not a lot else but health and safety, it seems, over the past 9 months. So I wanted to run through your obligations, your legal duties in respect of health and safety. You've got a statutory and a common law duty in respect of health and safety. The first one is set out in the Health and Safety at Work Act, which I'm sure you're familiar with. And that's to ensure, so far as is reasonably practicable, the health and safety of your employees while they're at work. You also have a common law duty, and that's to take reasonable care of the health and safety of your employees and ensure that they don't take any unnecessary risks while they're at work. So I think it's important to note with both of those points that there isn't a duty to eliminate risk completely in the workforce, but only to go so far as is reasonably practicable. And there's a balancing exercise that exists between looking at the risks to employees and the steps and measures you can take as an employer to guard against those risks. And I have no doubt you're familiar with because of the very obvious risks that are that firefighters go through in the operational work that they undertake. And I was reading a health and safety executive document about that and recognising the fact that that is a really difficult balancing act for you to carry out on a regular basis. You've also got the statutory obligation to carry out risk assessments. And this again is something which has kind of risen really high up the agenda over the past 9 months. I'm sure you'll be familiar with carrying out workplace risk assessments. But since COVID came about in March, we've been looking at workplace risk assessment to try and identify where the risk of transmission is high, and then looking at individual risk assessments, because there are some very specific risk factors which mean that certain individuals, certain employees have a greater risk of dying if they contract COVID. And so what we've been doing is looking at these two sets of risk assessments and working out that where you've got a very high risk individual, that they should be moved away from a high risk place. And that involves redeployment quite often and changing terms and conditions of contract. And that's caused some controversy actually over the past 9 months. So you'll be familiar with your risk assessments, hopefully. We produced a flowchart on that, which I think AFSA circulated, which was hopefully useful. But it's a process that you have to keep reviewing. You can't carry out the risk assessment and then forget it. You have to keep reviewing it. So in terms of disability, the reason I'm going to talk about this now and how it's linked to the risk assessments and COVID is that you will have had some very high risk individuals, and it's likely that they would have included your vulnerable employees and your clinically extremely vulnerable employees. Those are the individuals who were shielding at the beginning of the pandemic and recently have been asked to shield again, but in a slightly different way. Some of those individuals will be disabled. And so the next part of the talk, I'm going to look at the definition of disability and some of your obligations in respect of your disabled employees. So we've got the definition there, which hopefully you're familiar with, but it's basically where a person has a physical or mental impairment, and Jill obviously focused on the mental well-being of staff, which is incredibly important, but it's where the impairment has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. And you'll probably be aware that long-term in this context is where the impairment has lasted 12 months or is likely to last 12 months or more. And if an individual does have a disability, and often it's difficult to establish whether it's a disability, but often that will include a reference to your occupational health provider and asking them some very specific questions around disability and whether the individual falls within the category of a disabled person, because they will only benefit from the protection which is offered under the Equality Act if they do satisfy that definition. If they do satisfy that definition, then the protection that they are offered by the Equality Act includes that against direct discrimination, and that's where someone is treated differently and less well because of a disability. It doesn't have to be their disability. It could be that of another person. That's associative disability discrimination, or a perceived disability. So that fits under the category of direct discrimination. It could also be an indirect discrimination, where you have a workplace rule, criteria, or practice which applies to all employees, but disadvantages those who are disabled. You can also, a disabled individual also has protection against harassment, that's unwanted conduct related to the person's disability, or victimisation, that's when you treat someone unfairly because they've made or supported a complaint about disability discrimination. And the final point, which is different from the other protected characteristics we have under the Equality Act, is discrimination arising from a disability. They retermed it. It used to be discrimination related to a disability. And that's where an individual is treated unfavourably because of something that's linked to their disability. Not the actual disability, but something linked to that. And an example would be where the disability of an individual means that they have to frequently attend hospital appointments, and an employer decides that they can't, well, treats them unfavourably because they're taking a lot of time off in order to go to those hospital appointments. The final form of disability discrimination, which is actually the most common form and which you will, I hope, be aware of, is the duty to make reasonable adjustments for disabled employees. And this is the most common form of disability discrimination. So you have to look at whether you have operate a provision, criteria, or practice, or is there a physical feature which places the disabled person at a disadvantage? And if there is, you need to take steps that are reasonable in order to avoid the disadvantage. And that reasonable word is very important. Where that duty arises, there will be a claim against the employer where there is a failure to make the reasonable adjustments. And so, as employers, you need to take steps to avoid the disadvantage or reduce it to a manageable level. And I've put some bullet points there, which will hopefully be useful for you as a trigger point when you're looking at reasonable adjustments. So again, looking at reasonable, and only when it alleviates the disadvantage, and pay is not normally considered adjustment. There's been quite a lot of case law on whether it's necessary to extend sick leave and sick pay in order to, whether that is a reasonable adjustment, and generally it's found that it's not. So you have your legal duties under the Health and Safety at Work Act, the Common Law Health and Duty of Care in respect of health and safety, and under the Equality Act in respect of disability. Where individuals have concerns, employees have concerns, and you want to manage an individual who is disabled, there are certain employment rights that you need to consider. And I've set these out on these slides here. And this is when you're approaching a situation and are going to possibly take steps in relation to that individual. The first one is in relation to these health and safety concerns that individuals have. And I'm thinking here in the context of COVID at the moment, because this is when this issue is coming up, and it's something that not many employers know about, actually, because they possibly haven't had to deal with it previously. And this is where an individual raises concerns about their health and safety in the workplace and says that, well, I'm not going to come into work because of the danger, the imminent danger to my health and safety, or I'm going to take measures to prevent that imminent danger from causing me harm. And under the Employment Rights Act, where an individual is protected, they have, or falls under that category, they have two distinct rights under Section 44 and Section 100. Section 44 of the Employment Rights Act provides individuals who are protected with the right not to be treated detrimentally. And they
Nicky, can I just stop you there for a second?
Yeah.
Let's just have a chat on that. I had a phone call from an individual, an AFSA member. They were diabetic, type 2, under medication. And their employer said, we've done the personal risk assessment of yourself for COVID, and we deem you fit to come to work under these protected characteristics, under this risk assessment of the workplace. So this is what you need to do. The individual did not want to go to work, said they were mentally stressed out by the thought of having to come to work. Obviously, everybody's risk is different in their own mind, but the organization is the one that's responsible for the making the assessment whether the workplace is fit for work or not. How do we deal with that delicate situation?
This is so difficult, and this is coming up time and time again. And we advise fire and rescue services, police forces. We also advise NHS trusts, and I'm dealing with this on a daily basis. So you have individuals.
That's why I'm asking you, because it's free here.
I know. So you've had your risk assessment of the workplace, and you've identified a high risk area where the individual works potentially, and you've got your individual risk assessments, and this individual may have been identified as medium to high risk. You tend to have a matrix that is used in a scoring matrix going from 0 to 9, and maybe this person fits within 4 or 5. So they're not the very highest risk category where you're having to send them home and saying, I'm sorry, but you can't come into the office or workplace, but they're mid-range. And what the employer must do, their absolute obligation, is to be able to provide the individual with a safe place to work. That's that base level, that's section 2 of the Health and Safety at Work Act. Can you ensure the individual's health and safety so far as is reasonably practical? Now, in the risk assessment process, you will identify measures that can be taken to ensure the health and safety of that individual. And I don't know what measures you put in place here, but for example, that could be the wearing of PPE, that could be perspex shields being put up between desks, that could be having the person work in isolation, depending on how high risk they are. Provided the employer is comfortable with the risk assessment and says that, yes, I can provide a safe place for you to work, then if the individual is saying that they refuse to come into work, you're getting into conduct matters and
Yes.
Basically refusing a reasonable management instruction. Now, this is really, really controversial, and there are not many employers that are willing to go down that line at present, but we are getting to that point now because we've had 9 months of this situation. No, we've had longer. No, 9 months. And we are now looking to the future and saying, well, great, there's a vaccine that may be coming along, but we still have quite a long time to go before we can say to everybody, it is absolutely safe for you to come back into the workplace. And so these measures...
Absolutely agree. So let's take this further, because I think a discussion is the kind of stuff that people would welcome. So you've put in with and this is another area of concern for me. It goes back to the old Health and Safety at Work Act, the 6-pack that came in from Europe, when we all went down the road of the first risk assessments I remember in the 80s were firefighters, hand injuries were popular, yeah? Everywhere you went, firefighters. So we gave them gloves. The gloves were really thick. They didn't like wearing the gloves. They said dexterity was an issue, so wouldn't wear the gloves. They still got injured. Now, the firefighters were saying, it's our choice. We've taken the gloves off, so if you get injured, it's our responsibility. Now, they were then quite clearly told, no, it's management's responsibility. You will wear the gloves. Now, this is the same thing. It's the same thing repeating itself now under COVID. Yeah. Management says, wash your hands every 20 minutes. Management says, wear a mask. Management says, keep 2 meters away from other colleagues. Now, I fear if fire and rescue services have had a COVID spread in a location, it's an IT room or watch room, it's going to be because those rules were not being obeyed. You, as fire service managers, are liable because you have not enforced the regulations and the safety controls that are being put in place. It is not the individual that's responsible for breaching the rules. You are responsible because you allowed the breaches.
I'd make a couple of points there. So in relation to the firefighters who were taking off their gloves and saying, I'm taking them off, it's my choice to take them off. Your health and employers' health and safety obligations under the Health and Safety at Work Act are non-delegable, because we've had individuals saying, I'll sign a waiver, I'll work in a high risk area. I don't care, I want to do it, I want to keep working, particularly doctors. I mean, it's really admirable a lot of the time. Yeah. But a waiver is worth absolutely nothing under English law. You can't waive rights in respect of personal injury and death. And so it may well be that they want to carry on and they want to take their gloves off. But as an employer, you can't rely on that individual's decision. Now, there's another point to make under the Health and Safety at Work Act, and that's under Section 7, that employees have a responsibility to ensure their health and safety and safety of those they work with, and to follow reasonable instructions from the employer about health and safety. And a great example of this is mask refusers. So this is coming up time and time again, people who are not willing to wear masks. And some of the pushback for this is, well, I, as an employer, have a responsibility to ensure your health and safety and the health and safety of other employees. Plus, you have a to follow my instructions and to protect your health and safety and that of your employees. So you have to go with like a two-pronged approach with this, I think.
Let me just stop you there. Absolutely. So the theory is great, isn't it? I still don't believe that the enforcement is going on in the manner in which a command and control organisation does in the NHS. So in the fire service, I believe command and control, oi, get your mask on. They put the mask on. I believe that that managers are walking past colleagues who are breaching their written instructions. And that's where my fear is. There is going to be a major spread in a workplace where they've got great written procedures, and the procedures have been on a daily basis being breached by individuals, and they're going to try and blame the individual for breaching the procedures. I don't think they've got a leg to stand on. I think the managerial responsibility.
I think there is management responsibility. I think there is individual responsibility as well. And I think it's really important to reiterate that to employees. But the point that Vince makes is really important, actually, and I'm going to get onto that. I agree with you. I think if we think that people are not following the 2 meter distance rules, the hand washing rules, sanitizing the face mask, any of those rules, we need to keep reinforcing it as employers. And if it's a repeated offence, it is okay, I think, to start moving down a disciplinary process after informal processes. I agree with you. I think there is this real balance between looking after people, having a chat and moving straight into disciplinary processes, because that for me feels a bit much at first. But once you've exhausted those informal processes, then with some individuals, I fear that you will have no choice but to follow a disciplinary process.
Okay, let me ask you I'll ask you a final question on the informal procedure. So Jack Singh sees Nicky for the 3rd time not wearing a mask. I go, Nicky, I'm giving you an informal written warning. Remember, it has to be recorded somewhere that you've taken management action. If you haven't recorded the informal warning, it almost doesn't stand scrutiny, because when you go to a coroner's court or when you go to an employment tribunal, they will seek evidence. The evidence has to be written down, even if it's informal. So take that as piece of. Nicky, do you mind if this little conversation we've just had? We have recorded it. We'll see if we can get a soundbite of your presentation and get it out there, because I think there's a bit of misunderstanding. Are you happy with that?
I don't mind. Yeah, I mean it's a really, really complex area, this, and it's controversial as well, and there are real heightened emotions involved from employees. So I think you have to tread very, very carefully with this. The emails I see from employees about the reasons why they don't want to wear masks or there are COVID deniers, there are people, and the vaccine will bring in huge, huge issues here. And I'd be wary about putting out employer-wide communications on this. It's really about a case-by-case basis and understanding people's reasons why they have an objection and what their reason is for having health and safety concerns. You really have to drill down into this, which is why I think these informal discussions have to take place first. I would really counsel against saying, right, firm-wide policy, organisation-wide policy, this has to be obeyed, because you always have to think about an individual circumstances.
I agree. Let's keep going then. So
that was briefly touching on the health and safety concerns of individuals. And this is what we're coming up against a lot at the moment, is people that don't want to work in certain areas. They don't want to come back to work, for example. So for instance, you've had an individual who has been shielding and they have been potentially working from home, redeployed in some way, still being paid. But at this point, they refuse to come back. They don't want to come back, even though lockdown has been lifted. Now, you as an organisation have to make a decision about whether you can continue with the individual in the role at home or the redeployed role, or whether you really need them to come back. And this is where it becomes really difficult, because the individual will say, I have health and safety concerns, potentially whistleblowing concerns. So what actions can you take as an employer? Because they have these additional protections under Section 44 and Section 100. Section 100 provides someone who is dismissed for health and safety concerns with an automatic unfair dismissal claim. Section 44 provides them with protection against detriment. So they have this protection. You need to tread carefully. You need to understand exactly why they are raising the concerns they are. If they are baseless, then potentially you could move to conduct, potentially even capability if we're moving towards dismissal and you need that person in the role. But it really, really depends on the reasons why they're raising objections. And that's why I would always encourage you to have those conversations with individuals, document it all. Jag's absolutely right. Document it all, because we are already starting to see the claims coming in. We had our first one in yesterday on health and safety during COVID. And this will be huge next year. I can guarantee it. It will be absolutely huge. So if you are getting to a situation where an individual is refusing to come back to work and you deem it safe for them to come back to work and you have no work for them to do, say, for example, at home, what do you do with them? Are you prepared to keep paying them to be at home and not working? Most employers aren't, because we just don't know when this is going to end. Do you start taking disciplinary action and warning them? Is a potential option withdrawing pay? Now, unless you have the right under the contract of employment to withdraw pay, there is likely to be a breach of contract claim there and an unlawful deductions from wages claim. So you need to bear that in mind if you do want to stop pay. And I could talk for a long time, not very long. So this is just one of these trigger points that I want you to think about if you are going to take disciplinary action. The next point is being received. The claims that are being received are health and safety at work. A question has just come in, what type of claims are being received? And the claims that I'm seeing at the moment are under Section 44 and Section 100 of the Employment Rights Act, concerns about health and safety. Constructive unfair dismissal could occur if you move to discipline an individual because they are refusing to come back into the office. They could claim that you have breached the term of trust and confidence in their contract, which enables them to treat the contract as terminated and that they have been constructively unfair dismissed. It's a high hurdle for them to get over in an employment tribunal, but it's not beyond the realms of possibility. The final claim you need to think about is the protection under the Equality Act. Some of these individuals who are refusing to come back into the workplace will be disabled, and therefore we need to think about your obligations, things I talked about at the beginning in respect to disability discrimination, and the duty to make reasonable adjustments. But I would say that the duty is only so far as is reasonable. I don't think it's necessarily reasonable to have someone on unlimited paid time working at home, not doing any work. So, but you need to think very carefully. So I realise that I'm saying, crikey, there's claims everywhere, but there really could be, there's a lot of protection that's in place here for a very good reason, actually. But employers need to tread very carefully. Okay.
Nicky, I think it's been wonderful. We may have to go into case law over COVID when it appears. So I mean, there's so much, as you say. There was the black nurse in a hospital that was pregnant that shouldn't have even been at work, and she volunteered to come into work, but that's the organisation responsibility. There's the Sikh doctor that was working in A&E without a face-fit mask. There's the issues, particularly in the NHS, where they're not being given proper face-fit masks with facial hair. They've got the option of hoods. You got so much going on here. I think you're going to be pretty popular for organisations to help and support.
It has been a really challenging 9 months for people working in HR and dealing with this, because it's not an area, health and safety, that generally HR professionals are particularly comfortable with. It tends to be designated and someone else has responsibility for it. But we are going to have to get up to speed very, very quickly on this, because it's not going anywhere. I just want to show people what's here. So this is the slide that you can have a look at if you have an individual who has health and safety concerns. Explore all the options. This is about engaging with people. Throughout this pandemic, our advice has been, don't take a hard line with this. Engage with your staff. It's about winning hearts and minds. It really is. And there is an awful lot you can change by having an open and honest conversation with an individual. Prime example are a lot of BAME individuals who didn't want to have risk assessments carried out because they feared that they would suffer a detriment if they did. Actually, if you explain the basis for the risk assessment, more staff are willing to have that risk assessment. So it's about really having an open conversation. Document everything. These are the options, the alternatives that are open to you if an individual doesn't want to come back. And then the next slides, the next 2 slides, are about reasonable adjustments and the do's and don'ts. And actually, I spoke to Dal earlier, and I think you're going to use those slides, Dal, in a newsletter. So rather than me speaking about them now in our last 7 minutes, I suggest that you just have a bit of a read in your own time. And if you've got any questions on reasonable adjustments, please feel free to ask me about them. Hopefully most of these slides and most of these points are common sense, but the biggest issue and the most pressing issue for me at the moment for him is in respect of health and safety concerns and how disability links with that.